This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about the clear language of an insurance contract and why, if it's clear and unambiguous, it controls the interpretation of an insurance policy, and why the failure to name a party as an additional insured defeats the claim of the party seeking additional insured access to contract's rights of defense, and why contract interpretation is always based on the clear and unambiguous language of the policy. In Associated Industries Insurance Company versus Sentinel Insurance Company, the United States District Court for the Southern District of New York, on June 16, 2029, dealt with an insurance coverage dispute arising from a personal injury action in New York State Supreme Court, the trial court. The underlying action, Eduardo Molina versus Venchi 2 LLC et al., concerned injuries allegedly resulting from a construction accident at a premises owned by Central Area Equities Associations LLC or CAEA, and leased by Venchi 2 LLC, with the United States District Court required to determine who was entitled to a defense from which insurer. The parties involved were CAEA, who was insured by Associated Industries Insurance Company, Inc., and Venchi 2 LLC, insured by Sentinel Insurance Company Limited through its parent entity, Venchi US, Inc. Associated sought a summary judgment declaring that Sentinel had a duty to defend and indemnify CAEA in the underlying action, and that Sentinel's coverage was primary while Associates' coverage was excess. Sentinel, on the other hand, opposed this and sought a summary judgment for itself, declaring that CAEA does not qualify as an additional insured under the policy held by Venchi US, and therefore Sentinel does not have a duty to defend and indemnify CAEA. The court's decision was that Associated's motion for summary judgment was to be granted and Sentinel's motion for summary judgment was to be rejected. The court held that CAEA is not entitled to additional insured coverage under the Sentinel policy, and therefore Sentinel does not have a duty to defend and or indemnify CAEA in the underlying action. On September 20, 2018, Eduardo Molina, a construction worker, allegedly fell from a scaffold while working on a project in New York City. Molina sued Venchi 2, CAE, and Transworld Equities, Inc., asserting claims of common law negligence and failure to provide a safe workplace under the New York labor law and the industrial code. Sentinel issued a policy to Venchi US for the period October 13, 2017 to 2018, with Venchi US as the only named insured. Transworld Equities, Inc. was insured by Associated for the period April 16, 2018 to 2019, and CAE was identified as a named insured. The court concluded that Sentinel did not have a duty to defend and indemnify CAEA in the underlying action, and that Sentinel was not required to reimburse Associated for any costs. Under New York law, it is well established that courts determining a dispute over insurance coverage must first look to the language of the policy, and the language of the policy is then to be interpreted according to general rules of contract interpretation. An insurance contract is interpreted to give effect to the intent of the parties as expressed in the clear language of the contract. If a contract is unambiguous, courts are required to give effect to the contract as written and may not consider extrinsic evidence to alter or interpret its meaning. A contract is not ambiguous if the language it uses has a definite and precise meaning unattended by danger of misconception in the purport of the agreement itself and concerning which there is no reasonable basis for a difference of opinion. Unambiguous provisions of an insurance policy are to be given their plain and ordinary meaning, and the plain and ordinary meaning of words may not be disregarded to find an ambiguity where none exists. Given the court's holding that CAEA is not entitled to additional insured coverage, the court further held that 1. Sentinel does not have a duty to defend and indemnify CAEA in the underlying action, which mooted Associated's further request for relief regarding a declaration that Associated's coverage is excess, and 2. Sentinel is not required to reimburse for costs incurred or that will be incurred defending and, if necessary, indemnifying CAEA in the underlying action. The court therefore concluded that for the foregoing reasons, Sentinel's motion for summary judgment was denied and Associates' motion for summary judgment was granted. In my opinion, a person can only become an additional insured on a liability policy if he, she, or it is named on the policy itself as an additional insured, or by the terms of the contract. Even if unnamed, the person or entity is entitled to additional insured rights. The court found they did not exist. The right to a defense does not exist as an additional insured because the court concluded from the clear and unambiguous language of the policy there was no coverage owed by Sentinel to CAEA. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, please tell your friends and colleagues about the blog. And if you view these videos, please click on the like button at YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.